Hi everyone, I'm Sabrina.
And I'm Jonathan. We're the lawyers at Verity Law.
Today, we will list all the steps involved in estate administration. When we pass, our beneficiaries do not just get their inheritance automatically. There are many things they must do before that happens, such as filing insurance claims, applying to court for approval, and paying our taxes and debts. Only after all that, they can get their inheritance. Today, we will teach you the 6 steps involved in this process so you can know what to do first and what to leave last to avoid much wasted penalties, fees, and time.
There are 2 types of estate assets, those that require court approval to be passed down to your beneficiaries and those that do not require court approval. This means the beneficiaries only need to provide the death certificate to get those assets immediately. So step 1 is to file a claim for those assets. Let's use the example of the Parker family. Mr. Parker tragically passes away, but he was smart and left his children some life insurance.
So step 1 is for the Parker children to file a claim with the life insurance company. But how do they know which company and how much money they will be getting? This is a great question because all life insurance details are kept private and will only be revealed to the named beneficiaries.
This is why we do an asset list for all of our estate clients. When coming to our office to do their will, we ask clients like Mr. Parker to write down all of his current assets. Specifically, he will write down his life insurance company, the policy number, and approximately how much his beneficiaries should be getting upon his passing. Since this is an informal asset list, not a court document, Mr. Parker may update this list at any time by himself for free. Unlike a will, Mr. Parker does not need to go to a lawyer's office to update his asset list.
Now that his children have his asset list, they know to go to Sun Life and ask for a payout on policy number ABC. They also know approximately how much each of them is getting to avoid Sun Life making a mistake on the payout amount. After completing the claim form and submitting the death certificate, they only need to wait for around 1 month to get the life insurance payouts.
Now, step 2 is for the children to stop all pre-authorized payments and to pay out any debts. For example, Mr. Parker pays his internet and phone bills every month. They should inform Rogers that Mr. Parker has passed away, so all monthly payments should stop immediately. They should also go to the bank and stop all monthly pre-authorized payments made to Rogers. Any credit cards should also be immediately canceled.
But there are some existing debts that they cannot get out of, such as a mortgage on a house they will inherit. If Mr. Parker has done great estate planning, then the life insurance payout should just be enough to pay off the existing mortgage and any other debt Mr. Parker may have.
But if the life insurance payout is not enough, then they're in real trouble. For a registered debt such as a mortgage, the bank is entitled to sell Mr. Parker's property after 15 days of non-payment, though they will typically wait for 6 months or more. It does not matter that Mr. Parker is deceased. To the banks, non-payments are non-payments.
The children should also look to Mr. Parker's TFSA and RRSP at the bank. They can get money from those accounts right away if Mr. Parker set them as designated beneficiaries. Lastly, any assets that the children hold jointly with Mr. Parker, such as real estate and bank accounts, they can get those immediately with just a death certificate.
But if all that money is not enough to pay off Mr. Parker's debts, then the children must go to step 3, apply for court approval or probate right away. They should immediately hire an estate lawyer and apply for probate. This process is much faster, cheaper, and simpler with a will. Without a will, the preparation and processing time could take several years.
And on the probate application, it will ask for a list of assets owned by Mr. Parker. This is why just having a will stating everything Mr. Parker owns goes to his children is not enough to make things simple. If we do not have a list of assets, then the lawyer and the children will need to go to all major financial institutions and search for Mr. Parker's assets. To make things worse, many organizations will refuse to talk to lawyers who are the beneficiaries due to privacy reasons.
But if Mr. Parker already has a list of his assets detailing his real estate properties, bank accounts, and investments, then this search process is very simple. The will and list of assets will both show what he has and give his children or their lawyer authority to get further information if required.
Now, even if the will says the house goes to Mr. Parker's children, they cannot inherit his mortgage. This is because mortgage is income tested, and his children do not have the same income and credit history as he does. So his children will need to inform the mortgage lender that their dad passed away immediately and they're currently applying for probate.
This is very important. Usually, once informed, the bank will wait for probate to be done before asking for any further payments towards the mortgage. But if they are left in the dark, they will likely sell the house after a few months of mortgage non-payment.
At this point, the children should tell the bank whether they intend to sell the property or keep the property. If they want to sell it, they can list it right away while waiting for probate. But they must add a clause stating they can unilaterally extend the closing date depending on how long probate takes.
If they want to keep it, they should apply for mortgage pre-approval immediately, as this can take some time, so it's important to start early. This way, once probate is done, hopefully the mortgage approval is also done. Then their lawyer can transfer the property and the new mortgage into their names all at the same time. Keep in mind, if the children cannot pay off the existing mortgage, the real estate lawyer cannot transfer the property into their names, even with the court approval. They must first resolve the outstanding mortgage issue before the property transfer can take place.
Next, step 4 is paying the probate taxes. For the first $50,000 of Mr. Parker's estate is tax-free. Then, there's a 1.5% probate taxes on the entire estate. When calculating for the entire estate value, only mortgage may be deducted from it. All other debt, such as a vehicle debt or line of credit, cannot be used to lower the estate value and reduce the probate taxes payable. Now, normally, estate taxes must be paid when the children first apply for probate. However, a skilled lawyer can request an extension, so they will pay the taxes after receiving approval. We regularly get our clients 6 months to pay the estate taxes after approval.
The probate taxes are paid by completing an information form, similar to a tax return, and making a bank draft payable to the Minister of Finance, and then delivering that draft to the court that issued the probate approval. Easiest way is to have the same estate lawyer do this for you. As noted above, if you are able to defer the tax payment, you can get up to 6 months from your probate approval date to make this payment.
Now, step 5 is income taxes. Mr. Parker's children must hire an accountant and file his taxes for the final year of his life. This is called terminal tax return. By now, with the court approval, the children can open an estate account at any bank and access Mr. Parker's estate funds. They can use these funds to pay off the probate taxes and income taxes.
Finally, step 6. After paying all of the debts and taxes, Mr. Parker's children can take their inheritance. In Canada, there is no inheritance tax, so this is probably the largest sum of money they will receive tax-free.
Now, the steps 1 to 6 we listed is already the easiest version of estate administration. Things get a lot more complex if the estate is in dispute. For instance, if Mrs. Parker, Mr. Parker's previous wife, decides to make a claim for the estate.
If Mr. Parker has a will giving his children everything and there's no matrimonial home, then there's nothing Mrs. Parker can do, and his children are safe to receive their inheritance. But if there is no will, then according to legislation, Mrs. Parker would get the majority of the estate, being $350,000 plus 1/3 of the leftover, and his children would only get 2/3 of the leftover divided equally amongst them.
Also, if there are estate disputes or if there is no will, then the probate case is considered high risk. In those situations, court may ask the executor to purchase a bond insurance, which is typically 5% of the entire estate value. This way, if the court makes a mistake, then they can use the bond insurance payout to compensate the appropriate beneficiary.
But if there is a will, especially one with the bond exemption clause, then this costly insurance can be avoided. Mr. Parker's children can receive their inheritance without all the cost and mess.
To summarize, estate distribution can be an extremely expensive, long, and painful experience. Knowing what to do first and what to leave last is extremely important.
When we pass, our beneficiaries should do as follows. Step 1. Claim for life insurance, TFSA, RRSP, and joint accounts. Those can be issued very fast with the death certificate, usually within a month of the claim. Step 2. Stop all pre-authorized payments and pay out all estate debts, especially the mortgage. Step 3. Apply for court approval and tax payment deferral. This process is called probate.
Step 4. Pay off the 1.5% probate taxes using the estate funds. Step 5. Pay off the deceased income taxes for their last year. Step 6, and the last step, the beneficiaries get the inheritance tax-free. We hope this video is helpful, especially during your hardest times. We will see you in our next month's video.